Alright, I'm recording here and I'm waiting on the train to finish up. So I'm sitting here on the road waiting on the train, and I figured, what the heck, I'll read these minutes as I wait on this train right there.
I'll be 95, 176 to the Max building. Continuing 47488.
So it's going all the way back to my first hearing on February 15th. Let's see, minutes of the court. Let's see, resisting an officer. The defendant appeared in open court and proper person in the state was represented by Assistant District Attorney Clyde Benjamin. The court informed the state and the defendant that when a motion is filed, it will not be signed without a contradictory hearing with all the parties present. What? Why am I losing? You see my face? It just doesn't want to look up. Like it's broken. Okay. Without all parties present. You see me? Hearing on motion to dismiss, both parties gave oral arguments. The court finds the motion to be premature for the current process and at some point can be reiterated. Hearing on motion law and arguments, both parties gave oral argument before the court. Court denied motion because the court is bound by the Code of Judicial Ethics with the Supreme Court. The court informed the defendant that transcripts are available upon request for any court proceeding. Hearing on motion in order to set a matter for arraignment, in response in opposition in order to set matter for arraignment, both parties gave oral argument before the court. Court informed defendants that the arraignment did not have to take place today, could be left at the May 10th court date. Defendant accepts discovery from the state and asks that the arraignment be set for a later date. Court granted motion denying the arraignment set for February 15th and reset to March 7th as agreed upon by all parties involved. Hearing on second motion to quash Bill of Particulars and City of Natchitoches motion to quash defendant's motion to quash as it relates to improper admission of facts not in evidence, and City of Natchitoches motion to quash defendant's motion to dismiss. Both parties gave oral argument before the court. Court denies motion. Hearing on City of Natchitoches response to Bill of Particulars. The state provided the defendant with the entirety of discovery that they had at the time. Hearing on motion for discovery by the state. The state requested all videos that the defendant has and anything recorded in library. Court ordered defendant to present state with videos for state's preparation. The defendant requested an email for communication with the state. The court ordered state to provide thumb drive if the defendant can't access CD for discovery. Court ordered state to provide this defendant with an email for communication. Court informed the state and the defendant that the court is always available to meet with both. Just can't meet with the individual one of them if there is a pretrial matter. Hearing on motion to transfer venue to district courts in accordance with Louisiana Code Civ Pros 4873 for trial by jury. The defendant gave oral arguments before the court. Court denied motion because this is a criminal court and not a civil court, and the matter is a criminal matter and not a civil matter. The defendant requested that his bail be lowered to own recognizance. State objects to bail being lowered to own recognizance. Court denies oral motion because bonds exist to compel a person to come back, and also because the defendant is not a resident of Natchitoches. The court instructed the defendant and the state to file a motion with the court if there are any more issues involving discovery. Okay, and we have another hearing on March 7th, about a month later, 3 weeks. The defendant appeared in open court in proper person, and the state was represented by the Assistant District Attorney Clyde Benjamin. The court addressed issues with the defendant disobeying the court's order to not record the last hearing on February 15th. Hearing on motion for discovery by the city of Natchitoches, as it is time barred. The defendant gave oral arguments before the court, and the state objects to the substance of the motion. The court found the motion to be mute because it is out of date and denied motion because the laws have changed. The court asked the defendant about discovery from the states that was requested on February 15th. The defendant stated he does not plan to give discovery and will only use discovery provided by the state. The court orders the defendant to comply with all discovery requests. Hearing on motion for answer to City of Natchitoches motion to quash, defendant's motion to quash as it relates to improper admission of facts not in evidence, and request for reconsideration. The defendant stands on the motion and the state responded to motion. The court disputes some language that the court does not have jurisdiction over. Court does not have evidence to deny or accept motion because no evidence has been taken or verified with facts, and finds motion to be premature. Motion denied at the current time only. Hearing on motion in limine to suppress certain evidence. The defendant gave oral argument before the court. Court finds motion to be premature because there is no evidence and denies motion until the time of trial. The defendant was arraigned and entered a plea of not guilty. Trial set for March 23rd. Defendant made motion to resubmit motion in limine to suppress certain evidence. The court denies motion until trial. Alright, we jump from March 7th to March 23rd. Alright, the court gave an order that there would be no video or audio recording in the courtroom per the Supreme Court. Hearings on motion held 323. Present were the defendant, Travis Hines, and proper person, Morgan Bryce with Gold, attorney for Gold Weems Law Firm on behalf of City of Natchitoches, and Assistant District Attorney Clay Benjamin on behalf of the state. Hearing on motion to quash subpoena Deuces Tuckum and for protective order with incorporated memorandum in support. Court ordered no recording in the courtroom. Both parties gave oral arguments. The defendant objected to Bruce's motion. The defendant confirmed that he did receive training certificates from the police department. The court grants the city's motion to quash subpoena Deuces Tuckum in part because defendant was provided some information. Otherwise, the request is vague but did not grant the protective order. Hearing on motion in limine to suppress certain evidence and set suppression hearing pursuant to CCRP 703. Both parties gave oral arguments. The court finds the motion to be premature at this time, but will not dismiss it in case the defendant wants to bring it up at a later time. Hearing on motion to suppress witness statements and set suppression hearing pursuant to CCRP 703. The defendant requested an update on the witness that would be called by the state. State had no updated witness and requested discovery from the defendant. The defendant said he would not be presenting any evidence at the trial and would use the evidence that was given to him by the state. The court informed the defendant and the state that any information brought on the date of trial that has not been provided ahead of time would be barred. Court finds all discovery to be complete. Court denies and delays witness suppression. The defendant made motion to deposition the witnesses before the trial. The state objects because in criminal procedure there is the right of confrontation and you can't have a deposition of witnesses. The court denies the request to take a deposition because it is a civil request. In this case, isn't a civil matter. The defendant asked if he could contact the witness. State objects because court was held March 21st, 2022, and was limited to contact and information on the witnesses because they are afraid. The witnesses are afraid. The court denies the defendant any contact with the witnesses because he is his own attorney. Alright, we jump from March 23rd to March 21st. What? Okay, so that was, we're going backwards in time here. March 23rd to March 21st. Court gave order that there be no recording in the courtroom per Supreme Court order. Hines on motions, looks like they're moving. Hearing on motion and trials held March 21st, 2022. Present were the defendant, Travis Hines, and proper person. And the state was represented by Assistant District Attorney Clay Benjamin. Hearing on motion in limine to preclude publication of witness, video, and audio statements and for production and camera inspection. State gave oral arguments. The following exhibits were introduced by the state. Exhibit A, printed publication of the witness, R. LaCour. Exhibit B, screenshots of the library. Exhibit C and D, comments about librarian forum YouTube followers. And Exhibit E, live stream of comments in YouTube. The defendant objects to Exhibit B, A, B, and E. State gave oral arguments before the courts in response to defendant's objection to Exhibit B. State made motion that the defendant only be allowed to view the new video evidence in a controlled environment by the marshal and take any notes needed. Court accepts all exhibits and grants motion for camera inspection. Hearing on motion in limine to suppress witness statements and set suppression hearing pursuant to CCRP 703. Motion to suppress set for 3/23/2022, along with all previous motions that are set for that day. Hearing on defendant's response and objection to City of Natchitoches motion to quash. Response to City motion to quash subpoena duce tecum and for protective order. And defendants for motion to protective quash City preclude publication of witness, video, and audio statements of production and camera inspection. Defendant gave oral argument. Defendant requested a continuance for trial. Trial set. Okay, moving forward again. April 6th. All right. Hearing. Look at this. So now this new train takes over the road. That old train leaves and a new train takes over. All right. On April 6th, hearing on motion to appoint attorney held 4/6/2/22. Present were the defendant Travis Hines and proper person and Jason Methvin. Assistant District Attorney standing for Cloyd Benjamin. Assistant District Attorney. They did not. Okay. The defendant stood on his motion. Jason.
309 West Plains Boulevard for service of narcotic anger issues. 820 months South Ridge Nursing. 309 Rollins Boulevard.
What?
1310.
Jason Methvin gave oral arguments before the court and requested that the trial date of April 11th be maintained. Court asked the defendant if he tried to contact the public defender's office. The defendant stated that he tried to contact them, had received an application, but has not completed it. The court ordered the defendant to go to the public defender's office to do an application and complete the application process. The court will keep the trial date that sets, unless the public defender's office takes his case and requests a new trial date. Okay, on April 11th again. Oh no, okay, April 6th. And now we jump to April 11th. The court gave an order there be no video or audio recording in the courtroom. Hearing on motions and trial held President Clay Benjamin on behalf of the state and defendant Travis Hines in proper person. Hearing on motion for demands for court-appointed attorney. Court denied motion because the public defender's office found the defendant to have sufficient resources to hire an attorney. Hearing on motion for recusal of judge pursuant to Louisiana CCRP Art 151. Court denied motion because the Louisiana CCRP does not exist. Denial signed in open court and defendants provided a copy. Hearing on motion for objection to the denial of motion in limine to suppress certain evidence. Both parties gave oral argument before the court. Court denied motion to suppress and advised the defendant that he could raise any issues during the trial for any evidence he feels is not suitable to be in the record. The defendant requested all witnesses be sequestered. The court agreed. The following witnesses were sworn and testified on behalf of the state: Christine Stackhouse, Rosalind Parker, Carlos Jimenez, Officers Jordan Davis, Dispatcher Nakata Scott, Officer Thurman Miller Jr., and Officer La Quinta Scott. The following exhibits were introduced by the state. Exhibit 1, witness call to NPD on Data Stick Pro. Exhibit 2, Library Magazine Area Photo. Exhibit 3, witness video statement of Carlos Jimenez on ScanDisk. Exhibit 4, NPD dispatcher information call on ScanDisk. Exhibit 5, Officer Davis Library body cam footage on Data Stick Pro. And Exhibit 6, oh my god. And Exhibit 6, screenshot from the defendant's YouTube channel. All witnesses were cross-examined by the defendant. The defendant Thurman Miller as witness, who was sworn and testified. The following exhibits were introduced into evidence by the defendant. Exhibit 1, Rosalind Parker's written statement, and Exhibit 2, Rosalind Parker's video statement on ScanDisk. Oral arguments were given by both parties. The court finds the defendant guilty of resisting an officer. The sentence of the court was 30 days in the Natchitoches Parish Detention Center and 4 days credits for the time already served. Fines and costs total $411 with a fine payment date of July 19th, payable to the Natchitoches City Marshal. Upon detaining the defendant, the Marshal found an audio recorder. The recorder was seized by the City Marshal. The court informed the defendant that if any recording is found, he would be brought back before the court for a contempt of court hearing. Okay, we jump to April 11th. The court gave an order that there be no video or audio recording in the courtroom per the Supreme Court. Hearing on the motions and trial held April 11th, 2022. President Clay Benjamin on behalf of the state and defendant Travis Hines in proper person. Hearing on motion... Wait, did I read this? Hearing denial. All witness be sequestered. This is just a double take. They doubled that one up. I thought I saw one. May 2nd. The court gave an order that there be no video or audio recording in the courtroom per the Supreme Court. Hearing on motion held to 5/2/22. President Clay Benjamin on behalf of the state, the defendant Travis Hines in proper person, and Philip Adams, attorney for defendants. Hearing on motion to enroll. Court signed motion and Mr. Adams enrolled as counsel for the defendant. Hearing on defendant's notice of intent to apply for a writ of review. Request for a return dates and request for an extension of the return dates. Motion was discussed by phone conference on 4/28/22, and with Benjamin and Adams. Let's see. Benjamin and Adams. Motions signed within the 72-hour required by the state statute to decline or accept motions. Adams made an objection to hear defendant's second motion and to recuse first. Court denied because the court now has limited jurisdiction under Louisiana Criminal Code of Procedure, Article 916. Adams made motion that he was up against a 30-day time limit and had to have pleadings filed into record, not have his client rights waived, and his intent was to have post-trial motions heard before the return date was executed. Court informed Adams when the motion was signed and writ jurisdiction was given to the appellate court. The court went over Article 916 and its provisions. The court informed Adams that it could hear the following motions: motion to stay sentence and motion for post-verdict bail pursuant to Louisiana Code of Criminal Procedure, Article 312. Adam objects to any attempt to have his client's rights to have post-motions trials heard. Court overrules objection because this objection could have been withdrawn and then refiled. Adams requested to with the motion. Court denied because the motion has already been signed and it was discussed during the telephone conference. All parties agreed and the return date was set. Hearing on motion to previously filed defendant's motion for a new trial and second supplement to previously filed defendant motion for new trial. Court did not deny the motion but can't hear it because it has no jurisdiction. Hearing on motion to recuse, court informs Adams that if recused or files the appropriate process, the court will contact the Supreme Court. So the Supreme Court will elect an ad hoc, have a recusal hearing, and then make their determination. If recused, then they proceed. If not, he proceeds. Adam requested a moment to speak with his client. Court granted request. Adams made motion to withdraw, second motion to recuse, and address the two motions that the court could hear. Court grants withdrawal of second motion of recusal with prejudice. Hearing on motion to stay sentence and motion for post-verdict bail, Adams gave oral arguments. Adams requested an OR. State objects to OR. Adams gave response and rebuttal. Court denied motion to stay sentence and grants motion for post-verdict bail. Bond set at $1,500, which was the initial bond. Court informs Adams if his client's bonds out ahead of his sentence, there will be a final judgment or an overturning. If there is a final judgment, the defendant will have to serve the completion of his sentence. If the court has sent the matter back and the court is back in jurisdiction, there is a concern of a direct contempt of court violation. It will remain in limbo until the case is resolved. Court informs Adams about defendant July 19 court dates for his fine. Both instructed that one person has to present in court to give the status of the appeal for a continuance on the fine. Adams requested copies of all transcripts. Okay, and we're still waiting, but the train is now moving. Oh, let me stop this. So the train is now moving. And I'll stop this.